Okay, welcome back to part two of chapter four. Let's go ahead and jump right into our kind of second half, if you will. So now we're going to talk a little bit about criminal defenses. So, when people defend themselves against criminal charges, they must refute one or more of the elements of the crime of which they've been accused. Defendants may deny the actus reus by arguing that they were falsely, accused and the real culprit has yet to be identified. Defendants may also claim that although they did engage in the criminal act they are accused of, they lacked the mens rea or the intent needed to be found guilty of the crime. If a person whose mental state is impaired commits a criminal act, the person may seek to be excused of his or her criminal actions by claiming that he or she lacked the capacity to form sufficient intent to be held responsible criminally. So you have things like duress, insanity, intoxication, age, and entrapment are among the types of excuse defenses. Okay, and we're going to talk about that type, and then we're also going to talk about another type called justifications. And here the individual basically admits committing the criminal act, but maintains that the act was justified under the circumstances and that he or she, therefore, should not be held criminally liable. And among some of the justification defenses are consent or self-defense, necessity, or even law enforcement. Persons standing trial for criminal offenses may defend themselves by claiming either that their actions were justified under the circumstances or that their behavior should be excused by their lack of mens rea. If either of the physical or mental elements of a crime cannot be proved, then it's going to be a hard time for the prosecutor to actually convict that person. So, again, criminal defenses. So, as I said, defendants may deny the actus reus by arguments that they were falsely accused and that the real culprit has yet to be identified. And this would be what we call an alibi. Now, defendants may also claim that while they did engage in the criminal act they are accused of, they should be excused because they lacked that mens rea, right? This is an excuse defense. So by definition, excuses, a defense in which a person states that his or her mental state was so impaired that he or she lacked the capacity to form sufficient intent to be held criminally responsible. So excuses, again, are a defense in which a person states that their mental state was so impaired that they lacked the capacity, right, to be held responsible. And some of those that fall underneath this category would be duress, insanity, and entrapment. And, you look to the right and you can see a couple of interesting cases. And we're not going to go into the cases, but there's the first one, is the Raleigh woman who was stabbed 125 times by her husband, who used the cough syrup defense that basically said, when I woke up in the morning, she was dead and she was stabbed all these times, and I don't remember what happened. It must have been the cough syrup. And then there's another one where you hear, murder suspect blames death on sleepwalking. The Scott Falater case is a really famous sleepwalking case where he stabbed and drowned his wife, basically, and basically claimed the sleepwalking defense. So you're going to run across all kinds, but let's kind of take a look at each one of these just briefly. So, duress, if the defendant was forced to commit a crime as the only means to preventing death or serious harm to him or herself. So an example, maybe a bank employee might be excused from taking bank funds if they could prove that their family was being threatened and consequently she was acting under that duress, right? So that could be an example. Insanity, if the defendant's state of mind negates his or her criminal responsibility. Now, a successful defense results in a not guilty by reason of insanity verdict. Okay, so it is important to understand that. And insanity in this case it's a legal category as used in U.S. courts. It doesn't mean that everyone who suffers a form of mental illness can be excused from responsibility. Insanity, again, means that the defendant's state of mind at the time of the crime, so at the time of the crime, not before, after, etc., was committed, made it impossible for him or her to have the necessary mens rea, and we know what that means, to satisfy the legal definition of a crime. Okay, so that's, insanity. Then there could be intoxication. Now, as a general rule, intoxication, which may include drunkenness or being under the influence of drugs, is not considered a defense. However, a defendant who becomes involuntarily intoxicated, meaning they didn't know, right, because somebody slipped something in their drink or something like that, may be excused for crimes committed. All right, involuntary intoxication may also lessen the degree of a crime. Okay, so there's a little bit there. Age. The law holds that a child is not criminally responsible for actions committed at an age that precludes a full realization of the gravity of certain types of behavior. Now, generally, a conclusive presumption of incapacity for a child, is under the age of 7. And your textbook talks about it a little bit more. And it could be different from state to state, okay? And then entrapment. Under the rule of law, a defendant may be excused from criminal liability if he or she can convince the jury that the law enforcement agents used traps, decoys, and deception to, listen, induce criminal action. Now, law enforcement officers, they're allowed to set up traps for criminals by getting information about crimes from, informers, undercover agents, co-defendants, etc., right? Police officers are allowed to use ordinary opportunities for defendants to commit, crime, and to create these opportunities without excessive inducement. However, when the police instigate the crime, implant criminal ideas, or coerce individuals into bringing about crime, defendants can then claim that they have been entrapped. All right? And entrapment then must be viewed within the context of the defendant's predisposition to commit that particular crime. So that's entrapment. Okay, and now we're going to look at justification. All right, criminal defenses may be based on the concept of justification. And in these instances, defendants normally acknowledge that, hey, I committed the act, but claim they cannot be prosecuted because they were justified in doing so. And some of the major types of criminal defenses involving justification would be consent, self-defense, necessity, and law enforcement. So again, defendants may claim that the criminal act was reasonably or necessary, and that's part of the justification defense. So we're going to take a quick look at consent, self-defense, necessity, and law enforcement. And to your right, this is actually a video that was obtained where an off-duty law enforcement officer was with her kid and some other parents, etc., standing over here on the sidewalk. And you can see this guy here came up with a gun and was going to rob her, and she pulled a firearm out of her purse and ended up shooting the suspect, and he was taken into custody. So that was basically self-defense, right? And it could even fall under a couple of categories, but she was defending herself or defending others. So consent, the type of crime involved, generally determines the validity of consent as an appropriate legal defense. So as a general rule, the victim's consent to a crime does not automatically excuse the defendant who commits the action. The type of crime involved generally determines the validity, as I said, of consent as an appropriate legal defense. Such crimes are things like common law rape and larceny, require lack of consent on the part of the victim. In other words, a rape does not occur if the victim consents to sexual relations. Now, that's just generally. We know there's a lot more to it, right? But if you consent to something, then that can be a defense, okay? Self-defense. A criminal defendant can claim to be not guilty because he or she acted in self-defense. Now, to establish self-defense, the defendant must prove that they acted with a reasonable belief that he or she was in imminent danger of death or harm and had no reasonable means of escape from the assailant. And as a general rule, a person defending themselves may use only such force as necessary to prevent personal harm. And basically what they're saying by that last part is, let's say you defend yourself against an individual, and the person runs away and runs down the street. Well, you can't grab a bat, chase the person around the corner, and then beat them to death, okay? Because that's not reasonable, even though in your mind you probably think it is. Okay, so you can see that, again, you can only use that reasonable force necessary to prevent the harm. You can't actually turn the tables and go after someone continually. But you can defend yourself, even if that means, shooting, injuring, another individual. Necessity. So the defense of necessity is used when a crime was committed under extreme circumstances and really couldn't be avoided. Unlike the duress defense, which involves threats made by another person, people act out of necessity according to their own judgment, how they see things. Typically, to prove necessity, the burden is on the defendant to show that he or she acted to prevent imminent harm and that there were no legal alternatives to violating the law. Okay? So, using these criteria, a successful necessity defense could be launched if a woman in labor, fearing that she was about to give birth, stole a car in order to get to the hospital for an emergency delivery. So that kind of makes sense, right? It's out of necessity. And then finally, law enforcement. Police officers, firefighters, other first responders can use their occupation in defense of an alleged law violation committed while in the line of duty. So, example, a police officer who shoots a suspect he or she believes is, let's say, drawing a weapon, cannot be charged with murder even if it turns out that the suspect was unarmed. And that's why these are so controversial, and you see a lot of this in the news right now. However, there are a number of exceptions to this rule. First, the action must be contained within the scope of their duties. A police officer who uses physical force while buying marijuana from a dealer would be just as criminally liable as any citizen. Second, protection from criminal liability would be limited in cases of gross negligence or malicious intent. For example, police officers could be charged with criminal assault if they used, let's say, a weapon to batter a suspect they were interrogating, okay, because you're in an interrogation. So there's just a couple of things to understand, but you can use your profession, if it falls under the proper guidelines, as a justification for a defense. So, and you can kind of look at the picture like right here. if somebody was pointing a firearm directly at you and you were to, fire back, striking and, even killing the individual, you would have been justified in your actions. Okay, so let's just kind of talk a little bit now about reforming the criminal law. But I want you to know about the fact that things change. So criminal defenses are undergoing a rapid change. And as a society as society becomes more aware of existing social problems that may contribute to crime, it has become commonplace for defense counsels to defend their clients by raising a variety of new defenses based on pre-existing conditions or syndromes with which their clients were afflicted. Example could be battered woman syndrome, Gulf War syndrome, even child sexual abuse syndrome, Holocaust survival syndrome, and even adopted child syndrome. So in using these defenses, attorneys are basically asking judges to either recognize a new excuse for a crime or to fit these conditions into pre-existing defenses. Okay, so just kind of a lot to think about when we talk about changing defenses, etc. But now talking about reforming the criminal law. So in recent years, many states and the federal government have been examining their substantive criminal law, right? The elements and all that stuff. We've learned that. And because the law in part reflects public opinion and morality regarding various forms of behavior, what was considered maybe criminal 40 years ago may not be considered criminal today, right? In some cases, states have basically recessed their laws and reduced the penalties for some common practices like public intoxication. And this reduction of penalties is referred to what we call decriminalization. Such crimes which in the past might have resulted in a prison sentence may now be punished with a fine. In other instances, what was once considered a criminal act may, be declared non-criminal or legalized, like marijuana. Used to be criminal, and then, the moral compass and people kind of changed, etc., more accepting, what have you, whatever the reason is, and now it's legal to a certain extent. So some of the things that have kind of changed, and we'll go through each one quickly, would be stalking laws. All states have stalking statutes which prohibit and punish acts described typically as the willful, malicious, and repeated following and harassing of another person. And stalking laws were originally formulated to protect women terrorized by former, husbands, boyfriends. All those celebrities are often plagued by stalkers. Prohibiting assisted suicide. Some laws are created when public opinion turns against a previously legal practice, right? And you can remember the case of Dr. Jack Kevorkian. He was involved in assisted suicide. Registered sex offenders. Some legal changes have been prompted by public outrage over a particularly heinous crime. And one of the most well-known, of course, is Megan's Law, named after a 7-year-old by the name of Megan Kanka of Hamilton Township, New Jersey, who was killed back in 1994. So we have a couple of, there's sex offender registration and community notification that have kind of come out of that. Clarifying rape. Sometimes our laws are changed to clarify the definition of crime and to quell public debate over the boundaries of law. When does bad behavior cross the line into criminality? And when does it remain just bad behavior? So there are new statutes now relating to rape. Controlling technology. So changing technology and the ever-increasing role of technology in people's daily lives will require modifications to criminal law, right? Automatic teller machines, cellular phones have already kind of sprawled this new generation of criminality and criminal acts. So, phishing, cybersecurity, all that kind of stuff. Protecting the environment. Even in response to the concerns over environment, the federal government has passed numerous acts designed to protect the nation's well-being. We talked a little bit about legalizing marijuana because that's kind of a big one, right? Despite the federal ban on marijuana, 23 states currently have decriminalized the possession in small amounts and have legalized its use for recreational purposes. And other states have passed medical marijuana laws allowing its limited use for certain medical conditions. So you can see how the laws change. And, depending upon your opinion, it's good or bad. And we won't get into that debate, but sometimes laws do need to change and sometimes they don't, but we all kind of have our own personal opinion on that. And if you remember, you can go back to California's Proposition 64, where a yes vote supported legalizing recreational marijuana, a no vote opposed the legalization, and you can kind of look at the outcome right here. Okay, so now let's kind of finish up with, terrorism. Because this is another issue as it relates to criminal law where there are some ethical challenges here. So laws in part, again, reflect public opinion and morality. And when we talk about responding to terrorism, there are some issues, right? Because we want to protect the country, but we want to also maintain that balance. So soon after the September 11th attacks, the U.S. government enacted several laws focused on preventing further acts of violence against the United States and creating greater flexibility in the fight to control terrorist activity. And most importantly, Congress passed the USA Patriot Act, an acronym for Uniting and Strengthening America by Providing Appropriate Tools to Intercept and Obstruct Terrorism. That's a long one. And they did this on October 26, 2001. And the bill, which was over 342 pages long, created new laws and made changes to more than 15 different existing statutes. And its aim basically was to give sweeping new powers to domestic law enforcement and international intelligence agencies, FBI, NSA, CIA, in an effort to fight terrorism, to expand the definition of terrorist activities, and to alter sanctions for violent terrorists. So what is terrorism by definition? So includes the unlawful use of force or violence against any person or property to intimidate or coerce a government, the civilian population, or any segment thereof in furtherance of political objectives. So as I said, back in October 26, 2001, the USA Patriot Act was signed into law. It gave law enforcement the ability to search, detain, or eavesdrop in pursuit of terrorists. It also expanded all 4 traditional tools of surveillance, things like wiretaps, search warrants, pin, trap, and trace devices and orders, and also subpoenas. And it also focused on 3 kind of controversial provisions that were set to expire. One was what we call lone wolf terrorism. Well, it also allowed the government to track individuals who are not connected to a foreign power, but who are thought to be affiliated with a terrorist group. So that would be a lone wolf terrorism or a terrorist. It also applied to business records where the government can force third parties, such as travel and telephone companies, to provide access to a suspect's records without their knowledge. And then last would be what they call roving wiretaps. The government can monitor phone lines and internet accounts that a terrorist suspect may be using, but at first must get approval from what we call the FISA court or the Foreign Intelligence Surveillance Act. So as the Patriot Act expired, etc., enacted on June 2nd, 2015, the USA Freedom Act restored and kind of modified in modified form several provisions of the Patriot Act. Okay, so a lot of things were kept the same. A lot of things were kind of added in there. And if you don't know what the Freedom Act stands for, It's an acronym for United and Strengthening America by Fulfilling Rights and Ending Eavesdropping, Dragnet Collection, and Online Monitoring Act. And it restored portions of the Patriot Act that expired that same year. Roving wiretaps were reauthorized, as I said, as were provisions pertaining to lone wolf targets. And the act also placed some restrictions on intelligence agencies basically tracking or obtaining bulk metadata. And this change really was prompted in part by the actions of Edward Snowden, who was a former CIA employee who made headlines back in 2013, if you remember, when he leaked a lot of the NSA's surveillance information over WikiLeaks. So a lot of changes and things to kind of think about as it relates to our, procedure and, the law of criminal procedure, etc. Okay, so we are going to finish up with what we call the law of criminal procedure. So, whereas substantive criminal law primarily defines crimes, the law of criminal procedure consists of rules and procedures that are basically that govern the processing of criminal suspects and the conduct of criminal trials. So the right to remain silent, the right to an attorney, the right to a speedy and fair trial are all critical elements of criminal procedure, right? And the main source of procedural law is the body of the Constitution and the first 10 amendments added to the U.S. Constitution on December 15th, 1791. And these are collectively known as the Bill of Rights. And these amendments were added to the Constitution to basically kind of quell fears among some of the founding fathers. George Mason was probably the loudest one on this, that as drafted, the Constitution did not offer protections from the exercise of power by an all-powerful central government. Okay, so the Bill of Rights, super important. Okay, and part of this, what came out of a lot of this, would be judicial interpretation when you look at the Bill of Rights. So before we actually finish up with a couple of amendments, I want to talk about judicial interpretation and two things that kind of came about. So the purpose of these amendments that we were talking about was to prevent the government from usurping the personal freedoms of citizens. And the United States Supreme Court's interpretation of these amendments has served as the basis for creation of legal rights of the accused. Now, when the Supreme Court justices are conservative, they are less likely to create new rights and privileges and more likely to restrict civil liberties. So take what is known as the exclusionary rule. According to this judicial doctrine, it's not a law, it's a judicial doctrine, evidence seized by police in violation of, the rights and privilege presented by the Constitution cannot be used in a court of law. It is as if the incriminating evidence didn't even exist. Thus, if police make an illegal arrest and find illegal substances hidden on the suspect's body, that contraband can't be presented as evidence in trial. And some people think, hey, this is a great idea. This is a judicial doctrine. It's basically something that was formulated by the court to keep law enforcement in check and making sure they're doing things the right way. It's not a law. But some people thought, well, wow, we found the evidence on this guy, so why can't we use it against them? But if we didn't have that kind of bar set that high, would law enforcement just search everybody and we would usurp the rights and privileges that individuals have? And on top of that, kind of an extension, is something called the fruit of the poisonous tree. And this extends the exclusionary rule to make evidence inadmissible in court if it was derived from the evidence that was first illegally obtained. So if you illegally search someone and you find information, and that information leads you to $10 million worth of dope somewhere, that is an extension of what was first illegally found. Therefore, that is not usable in court. So these are important things. And again, this is part of judicial interpretation. So this is the exclusionary rule and the fruit of the poisonous tree. So now we're going to finish with looking at a couple of the important amendments, right? So a lot, we could say that they are all important, and they are. But of primary concern in the law of criminal procedure, right? The procedure, the process, etc., are the 4th, 5th, 6th, and 8th Amendment, which limit and control the manner in which federal government operates the justice system. And in addition, the Due Process Clause of the 14th Amendment has been interpreted as imposing limits on the government action at the state and local level. So the 4th Amendment, the right of the people to be secure in their persons, houses, papers, and effects against, not against searches, but against unreasonable searches and seizures, shall not be violated, and no warrant shall issue, meaning you can't get a search warrant, but upon probable cause. The same thing, you need to make an arrest. Supported by oath or affirmation, meaning that if you're going to get a warrant, you need probable cause. You need to take this paperwork to the judge. You need to swear by it, and then you can get your warrant signed. And then particularly describing the place to be searched and the persons or things to be seized, so that way you're not just fishing, you're being very detailed in the information that you're looking for. So the 4th Amendment, the interpretation, forbids unreasonable search and seizure. We talked about the exclusionary rule. 2 big case laws that go with that would be Weeks versus United States and Mapp versus Ohio. So it requires probable cause to search, probable cause to arrest, and then of course no warrant issued without probable cause. The 5th Amendment, no person shall be held to answer for capital or otherwise infamous crime unless on the presentment of an indictment of a grand jury, or now a preliminary hearing, except in cases arising in the land or naval forces or in the militia when actual service time of war or public danger, nor shall any person be subject for the same offense to be twice put in jeopardy of life or limb, tried twice for the same offense, nor be compelled in any criminal case to be a witness against himself, self-incrimination, nor be deprived of life, liberty, or property without due process of law, nor shall private property be taken for public use without just compensation. 6th Amendment, in all criminal prosecutions, the accused shall enjoy the right to a speedy and public trial by an impartial jury of the state and district wherein the crime shall have been committed, which district shall have been previously ascertained by law, and to be informed of the nature and cause of the accusation, to be confronted with the witnesses against you, him, them, and to have compulsory process for obtaining witness in their favor, and to have the assistance of counsel, right to an attorney, right to confront and cross-examine witnesses, right to use the subpoena power of the court, right to have a trial by a jury of your peers. The 8th Amendment, excessive bail shall not be required, nor excessive fines imposed, nor cruel and unusual punishments inflicted. So, no excessive bail, excessive fines, and typically the cruel and unusual part are issues related to the death penalty, etc. The due process of law. The concept of due process is found in both the 5th, we just read it, and 14th Amendments. Due process has been used to evaluate the constitutionality of legal statutes and to set standards and guidelines for fair procedures in the criminal justice system. Due process can be divided into a couple of categories, substantive and procedural. Substantive refers to the citizen's right to be protected from criminal laws that may be biased, discriminatory, or unfair. Procedural seeks to ensure that no person will be deprived of life, liberty, or property without those proper legal criminal processes. So a lot to cover. We just a hair over the 30-minute mark, so actually not too bad. So this will now conclude part 2 of chapter 4, criminal law, substance and procedure.